with the employer, and they turn you over to their corporate counsel,
Mark,
or
yes.
director of HR, whoever's handling it, right?
Mark, the first question we ask our client, give me the name of your supervisor or a person of impact in your employment career. Give me their direct number. The moment we're retained, that's my first call. We call a supervisor, they don't call back. We call HR, they don't call back. Inevitably, the attorney calls, which is good because the attorney representing the employer knows employment law. Our method is within 5 business days, we're in that attorney's office, closing the door, looking at the attorney's bridge of his or her nose, trying to impart wisdom. And again, as I said earlier, within 45-day life cycle, we can either get our client's position back or an acceptable severance package just by dealing in that backroom setting.
Okay. But before you sit down with that lawyer and look him in the eye, or her, you have to have some information. You have to say something like, you know, my client's elderly. This could be age discrimination. It could be sex discrimination. You have to, where do you get that information before you actually sit down and have that discussion?
Mark, our clients are our best source. We have a wonderful paralegal who is a great behind-the-scenes researcher, and when Bill indicated that last trial we had where we got this evidence, after a scrutiny with our client, after researching the employer with the computer, and he's terrific at technology, we're able to get a game plan formulated. And if we go in there and just say, hey, you know, the reasons are suspect, much of what we do is circumstantial. There is no hard evidence. This last trial was wonderful. We got males preferred. We got another one. We're representing an older woman in this particular case, Mark. And the second advertisement on the internet is, we are pleased to tell you that 85% of our workforce is age 35 and below. Now, Bill used to think that 35 was old. Now that he passed that threshold, he's got another mindset. But these are the things that we formulate, and we get a pretty sophisticated game plan, and Bill and I look at each case together, and when one of us goes into that corporate attorney's office, we know what we're doing.
Do you write for personnel file? Do they give it to you? Are you able to interview co-workers? Do you, you know?
At the pre-litigation phase,
you don't work it up
you're not going to get any cooperation as far as that kind of paperwork. What you need to do in pre-litigation is have your work with your client. It's a team effort with your clients, and sit down, have them draft what we call flavor beans. Give us what's going on. Give us a snapshot, a timeline, who, what, where, when, how, and use that information to leverage it. Not every time do you get something that you can use, but most of the times you will find that something happened to trigger this.
So you go into the attorney's office and you say, look, we can make life miserable for you. We'll start suit. Let's cut a deal here. And most of the time they'll cut a deal. What if they say to you, Coy or Coys, take a hike?
That happens, Mark. Our 2 best cases in our history, the attorneys told us to take a hike. So what we do at that time, we tell our client, you have a choice. You have a key choice. You can walk away with your head held high, knowing we tried everything in our power to work out a deal, or let's go get them.
And you file suit?
We file a complaint.
You go the litigation route.
A year plus later, we're in the hands of a judge and a jury. But even then, once the complaint is filed, Mark, they know we're even more serious. Deals are cut then. Through discovery, when we take my client's deposition, deals are cut then. Attorneys have a tendency to go for walks, and deals are arranged. And it is rare that a case goes to trial.
Let's talk about sexual harassment, hostile work environment. What is the definition of a hostile work environment?
Hostile work environment is essentially when something happens in the workplace that would offend any reasonable woman or person in that field, because now you can have a same-sex hostilities. It could be on gender, it could be on sexual orientation. But anything that happens that becomes part of the terms and conditions of employment that has been ratified by the company and makes somebody in an uncomfortable scenario. So it's a hostile work environment, whereas, for example, you have, and it's a fine line too, because there's obviously you want to have a fun workplace, but you want to have an appropriate workplace.
The banter around the
We've
water
gotten
cooler.
more cases from the banter around the water hole because
Yeah.
a lot of people don't know what is a reasonable way to act at work. Now, we've had cases where people have come to us and said, I was offended at this. Now, you have to use the reasonable person standard. You can't, if it's something that is not that you feel crossing that threshold, you have to tell that client. It's something that I don't think a court would view as a hostile act. But many of our cases, you would be shocked at some of the things that go on in the workplace.
Give us a couple of shockers.
We've had
No names.
no names, of course. We've had workers that are getting, the joke of the day is the internet now is a ripe new source of hostile work environments. We had a supervisor emailing a group of employees a joke of the day, which would include gross pornographic images, sexist jokes, things that would make anyone blush. And after our client said, please take me off this list, I am not comfortable with this content, it continued day in and day out. So things like that. We also have internet situations where people are cruising inappropriate sites at work, right in plain view in front of some of our clients.
Then, of course, you must have the dating or
Dating's a
hitting on your secretary.
That's quid pro quo. When quid pro quo is, we have scenarios where a supervisor goes to a worker and says, if you date me, I'll make sure you go far in the company. That is also sexual harassment and not acceptable as well.
How do you deal with the sexual harassment, hostile work environment type of a case? Same approach?
Same approach. It's a little more sensitive, of course, because you're dealing with individuals, and there are accusations, and they're serious, and a lot of them are married and families, so you have to be very careful when you go in with a sexual harassment claim. So I would say you have to handle it a little more with kid gloves, so to speak, when you're going to them, and make sure that you do it appropriately. But it's the same system. You go in, we call, we get a meeting, and we lay out exactly what happened. And the best evidence is what happened from our client's own mouth.
So if somebody has a sexual harassment case or a wrongful termination or just a firing, how do they pay you guys?
How do they pay us?
Yeah.
Mark, we
Is it
have
contingency?
We
Is it
have
hourly?
We have different arrangements. It is a rare day that we take a case on a full contingency. When you have severe and pervasive treatment, which is the standard for a hostile work environment, we assess that, and 9 times out of 10, we give the client the following choice. By law, we have to send them a retainer agreement, which explains what we can do and can't do. In the majority of our cases, we let them choose an hourly or what we call a hybrid arrangement, Mark. And the hybrid arrangement is we will cut the hourly sum, and in return, anything we get for them as far as settlement or a jury award, we take a piece.
A percentage?
Yes.
Okay. Bill and Bill, we've run out of time.
Really?
Yep, seems like we're just getting going. Maybe we'll have to do another show, and you'll come back.
Mark, we've enjoyed this, and we thank you
well,
for having us.
Thank you both for being on the show. And just one last question. Who resolves the employment disputes in your office between the two of you?
He takes over now.
I think my record speaks for itself.
There you go. Well, thank you both for being on the show.
Thank you, Mark.
Hi, you've been watching Law Talk Today. My name is Mark Gruber. Tune in next week. We'll have a different topic. If you have any ideas for shows, go to our website, lawtalktoday.tv. If you'd like to email about any questions about the show or ideas for new shows, info@lawtalktoday.tv. Again, I'm Mark Gruber. Good night, and thank you for watching.